I'm Marjane Frayne, the current president of the Plato Society of Los Angeles. For any people out there who are not familiar with Plato, we are a unique, independent, self-governed community of about 400 people who just really love to learn. Interaction, dialogue, and questions are the basis of learning at Plato. In addition to group discussions, we have colloquiums such as this today. We also have a day-long seminar during the year. We have retreats, lunchtime talks, documentary films, social events, foreign travel, and much more. We even have a bridge groups, and we have a mindfulness session once a month. So pick up, if you're not part of Plato, pick up one of our brochures out front before you leave. And our website, we have a new website address, platola.org. Our study groups start in January. Registration is going on now. And at this time, I'll introduce Jan Moulton, who is the chair of our Plato colloquiums.
Thank you, Marjane. Hi, everyone. It's great to see all of you here today. I think we have an exciting program planned for today. Before I introduce the speaker, I would like to mention 3 upcoming colloquiums that I hope will interest you. We're skipping December because it's such a busy month, but January 15th, we have District Attorney Jackie Lacey, and she will speak on alternative sentencing. And of course, you know that during the Q&A, you can always venture into some other areas as well. On February 19th, we have author Scott Berg. He has written a number of novels, among them Lindbergh, and his most recent book is Wilson. So that's February 19th. And then on March 27th, we have the Archbishop of Los Angeles, Jose Gomez, and he's always a fascinating speaker. Turning to today's program, we have as our speaker David Medine. He is chairman of the Privacy and Civil Liberties Oversight Board in Washington, D.C. And I want to thank very much Marianne Weil for her help in arranging the speaker. Mr. Medine started full-time in this position in May 2013. Previously, he was an attorney fellow for the Security and Exchange Commission and a special counsel at the Consumer Financial Protection Bureau. From 2002 to 2012, he was a partner in the law firm Wilmer Hale, where his practice focused on privacy and data security. Before then, he served briefly as a senior advisor to the White House National Economic Council. From 1992 to 2000, Mr. Medine worked at the Federal Trade Commission, where he was the associate director for financial practices. At the FTC, in addition to enforcing financial privacy laws, he took the lead on internet privacy and chaired a federal advisory committee on privacy issues. He earned his JD from the University of Chicago Law School. So I hope you can see that Mr. Medine has a wealth of experience in this area, and he is eminently qualified to discuss privacy and civil liberties in the post-Snowden era. Please join me in welcoming David Medine.
Good afternoon. Thank you, Jan, for the introduction, and thank you, Marianne. I've heard lots and lots about Plato over the years, and so it's very exciting to actually be here and see what you're all doing. Let me start off as a government employee with a disclaimer, which is that my comments today don't necessarily represent the views of the Privacy and Civil Liberties Oversight Board, or the other members of the board. These are my own views. So I want to go back and talk about how the board got started and what we've been up to. After the 9/11 attacks, as you may know, a commission was formed, the 9/11 Commission, to study what went wrong and how we can do better as a country to protect ourselves from terrorist attacks. And if you haven't read their report, I highly commend it. It reads more like a novel than a typical government report. And the report spends about 499 pages talking about how we can gather more information about potential terrorists and threats to the country, and how we can share information better and do a better job at protecting the national security. And around page 500, the report says, oh, and by the way, let's not go too far in the direction of national security so that we forget privacy and civil liberties, because those are values that are really what the country was founded on. And you really can't have one without the other, security or privacy and liberty. And so the 9/11 Commission recommended the creation of a board that helped the government balance those two concerns. So afterwards, a board was created in the White House, the Privacy and Civil Liberties Board, version 1, which is a White House entity with 5 board members. And as they started doing their work, the White House felt that it could edit some of their reports because they were a White House entity. But one of the members of the board resigned in protest and said there was undue White House interference in the board's operations. And so Congress agreed with that and abolished the Privacy Board at that point and recreated Privacy and Civil Liberties Oversight Board version 2.0, which is ours, as a independent agency in the executive branch. That's a bit of a non sequitur because either you're in the independent or you're in the executive branch. We are both. And in some ways, that's turned out to be a huge plus for us, because on the one hand, we are independent, and I'll talk about how we can make our own decisions without any oversight or other views, but we're also in the executive branch. And what that means is we have access to what the agencies are doing and thinking, and access to agency employees in a way that no one else can, because we're essentially part of the government. So it's actually, even though it's a strange concept, it's actually worked extremely well for us. So we were created as an independent board. We have 5 board members. No more than 3 board members can be of the same political party. So we currently have 3 Democrats and 2 Republicans. The board members are all nominated by the President and confirmed by the Senate, and we serve staggered 6-year terms. And our mission is twofold. One is to conduct oversight of existing federal counterterrorism programs and report as much as we can to the public and then to the President and Congress about the operations of those programs and whether they strike the right balance between national security and privacy and civil liberties. But we also have another very important function, which is advice. And that is really to help agencies get it right the first time. And so we advise members of the intelligence community as they develop new programs about the privacy and civil liberties aspects of those, as well as commenting on new laws and regulations. And that's part of our function that'll never be public, but I think it can be extremely meaningful if we can help them get it right the first time instead of having it leaked and then subject to a lot of criticism down the road. So we take both our oversight function and our advice function very seriously. But to let you know how I got involved in all this, in September of 2011, I was shopping at Whole Foods, and my cell phone rang. And a friend called and said, would you be interested in having your name put forward to the White House as to be chairman of the Privacy and Civil Liberties Oversight Board? And so my first question is, what's that? And I Googled it and looked up on Wikipedia and found out what it was all about, and it seemed like an interesting thing to do. At that point, the board still was dormant between its White House version and its current version because President Obama had not yet nominated a full slate, actually for quite a few years. And so I said sure, and I went ahead, and I don't recommend being a nominee because it took about 6 weeks of paperwork to financial background, employment, publications, on and on and on, up until I got to December of 2011 when President Obama finally nominated me and a couple of other board members to serve on the board. I thought that was the hard part. It turned out that was just the beginning of the process, and it took the Senate 510 days to confirm my nomination. Which is why, after I left the law firm, I did some work at the SEC and the CFPB. So after the long wait, but it ended up turning out okay in a way because I started in the board pretty much the first week in June of 2013. And I started at the board where we had no office at that time, we had no email system, we had no website, and we had no permanent staff, because as the chairman, I'm the only one statutorily authorized to hire staff. And so we had 2 detailees from different government agencies, one from the NSA and one from the Director of National Intelligence, and that was it. And then the 4 other board members who were part-time, I should add, and they have other jobs. So on day 1, there was really not much there to start with. But on day 4, Edward Snowden leaked So the question is, what do? We have barely an organization, but this is right in our lane. And so I had to decide on day 4, are we going to be relevant or are we going to be irrelevant to this whole debate of national security and privacy and civil liberties, and I thought it might be valuable to be relevant. And so on Friday of that week, I wrote a letter on behalf of the board to the Attorney General of the United States and to the Director of National Intelligence, and said, we would like a classified briefing on the 2 programs that Snowden had leaked that week, which I'll talk about some more. P.S. I don't have a security clearance. That was on Friday. On Monday, I had a security clearance. On Tuesday, we met in the bowels of the Justice Department with the NSA and the CIA and the FBI and the Justice Department, and had a briefing on the 2 programs. And the following week, we met with the President Obama and his senior staff in the Situation Room in the White House to talk about national security issues and how we go about examining these programs. So it was a rather exciting start to my tenure at the board. The 2 programs that Snowden leaked that first week, you may remember, are the so-called 215 program, which is a telephony metadata program, and the 702 program, which is sometimes called PRISM and Upstream. President Obama asked our board to conduct a study of both of those programs, and around the same time, 13 members of the Senate asked our board to do the same thing. And so that pretty much was the board's work for our first year. Is to conduct a study of the programs. And the way we went about studying them is to get access, I should add, all the members of the board and all of our staff have the highest possible security clearances, top secret, it's called top secret SCI. And so we started off by gathering relevant documents, including the decisions, classified versions of decisions by the Foreign Intelligence Surveillance Court and other government documents, and had numerous briefings with the various intelligence agencies, obviously, particularly the NSA, but the other agencies as well, involved in these programs. And for the first year, we had pretty much 2 professional staff I was able to hire to prepare our reports. We conducted public workshops and hearings, as well as, again, meeting in private with the relevant parties. So in the 215 report, let me just describe briefly the program, as you may know, is telephony metadata program, which is a program under which the NSA goes to telephone companies and says, basically, give us telephone metadata. Metadata is not the contents of the phone calls, it's data about data. So in this case, it's not the content of the call, it's the phone numbers that was dialed, the dialing number, the receiving phone number, the date and time the call was made, whether the call actually connected, and how long the call occurred, which is pretty much not location of the parties other than what the area code would reveal. And the purpose of that is to compile all that information as NSA database so that if, say, a terrorist calls from Afghanistan, calls someone in the United States, obviously the government would be quite interested in that. But the government would also be interested not only in who they called, but who that person called, because if that person was involved in a plot in the United States or assisting a plot, they would want to know if there are any co-conspirators. So the first link in what they call contact chaining is from the overseas person who is identified as a bad guy to someone in the United States. That's step 1. Step 2 is who the person in the United States called. That's the second step. And in some cases, the government went a third step, which is to take whoever that second person called and whoever they called, and to study and see if there were terrorist links or a plot underway in the United States. And so there's some debate as to whether there are privacy implications which I will talk about. But what our board did after we had gained an understanding of how the program operated is to sort of set a structure for how we're going to evaluate programs as part of our oversight function. And we look at three things. One is we look at the statutory analysis, which is the program complying with law? And I should add that some people wondered why, since we're not a court, we are looking at legal compliance issues. Congress specifically said we have two missions when we conduct oversight. First is to look at the balance between national security and privacy and civil liberties, and the other is compliance with law. So our first step is to say, is this program legal? The second step is the program constitutional? And there are First and Fourth Amendment issues that are potentially raised here. And then the third step is the policy question, which is how does a program strike the balance between the two competing concerns, not even competing concerns, sometimes complementary concerns. In any event, as we started looking at this program's statutory compliance, we found a mismatch. What had happened is this program had been leaked, which we're now quite familiar with, but quite a few years ago, and the government looked for a legal rationale for conducting the program which hadn't been conducted pursuant to statute. And someone found Section 215, which is a business records provision, and said, let's stick this program under Section 215. The problem is that 215 wasn't a really good match for the way this program was operating, and so our board concluded that the program was illegal. That is, the program in a number of respects did not comply with federal statute. For one is the statute talks about the FBI receiving this information from the phone companies, and as you know, it was the NSA that was receiving the information. The statute also says that the government should only collect information that's relevant to an investigation. How everyone's phone numbers in the United States is relevant to an investigation is a bit of a stretch, and we'd never seen in any precedent whatsoever, whether search warrants or other collection of information, the government taking a position in a court approving it, a relevant standard where everyone's conduct was subject to inquiry. Then there were other compliance issues, which is the government is basically prohibited from getting phone records except for certain situations. This was not one of those situations. So on and on and on, there were numerous reasons why this program did not match up with the statute. Then we turn to the constitutional analysis, which is the program consistent with the First and Fourth Amendments? And the Fourth Amendment, as you may know, has had an evolution over the years by the Supreme Court and what's covered by the Fourth Amendment, which normally requires a warrant for the government to conduct a search or a seizure. And then sort of for decades and maybe longer, the Fourth Amendment was viewed as only protecting property, so that it only applied when the government went into your home to conduct a search. And then there was a famous case called the Katz case, where the government surveilled a phone booth. For people who, our kids don't remember what phone booths are. But phone booths were people used to make calls in a glass enclosure, and the government would surveil people's communications in there. And that didn't fit very well with the model of protecting private property, because this was public and out there. But the Supreme Court in the Katz decision said, no, the Fourth Amendment protects people, not places. And so therefore, communications in a phone booth were covered. But then in the late 70s, a case arose in Baltimore of a man who was stalking a woman, and the police had an idea of who it might be. So they, without going to court and getting a warrant, they started essentially tapping into this person's calling records and to see what calls. They didn't even know if the call was completed, but they could see what numbers this person was dialing. And they did that for 2 days, and they found out that, in fact, this defendant called the person who was accusing him of harassing. And so on that basis, they arrested the person in Baltimore and convicted him. But his lawyer went all the way up to the Supreme Court and said that collection of my phone calling records, not the contents of his calls, but just 2 days of records, not even showing how long the call existed or even whether it was completed, but those 2 days were captured from him unconstitutionally. And the Supreme Court agreed and said, yes, that was a violation. I'm sorry, I take it back. The Supreme Court disagreed and said that because the information about the calling records had gone to the phone company, that person lost privacy interest in that calls because it went to a third party. And so what they created is the third party doctrine, which is when the government seeks information about you that you've given voluntarily and knowingly to a third party, as you do with your phone call records, that there's no Fourth Amendment issue there. The government captured that information without a warrant, and so they upheld the conviction. So fast forward now to current times, and we have a program that isn't about one person's phone records, it's about all of our phone records. It isn't about 2 days, it's about 5 years, and it's not about having suspicion about this particular person, but it's about suspicionless collection of this information. And so the question is, should that be permitted under the Fourth Amendment? The fact is that, and what our board concluded is, this case, Smith v. Maryland, is still good law. The Supreme Court hasn't overturned that case. And so we didn't feel in a position to say that that was not good law, although there's certainly some trends in the Supreme Court that are indicating that that might change over time. There's a case more recently called U.S. v. Jones, where they put a GPS tracking device on someone's car, and the Supreme Court said that that was unconstitutional because they touched the car, and that was trespass, which is not a very narrow ruling, but other justices said, like Justice Sotomayor and Justice Alito said, yes, we're fine with the way we ruled on this case, but there are greater concerns here, which is when the government's tracking someone over a long period of time, does that really cross over the line? And so it's unclear how that's, and then even more recently, just this year, there was the Riley case, where the police on a traffic stop took someone's cell phone and looked at everything on the cell phone. And the Supreme Court said, you know, cell phones aren't like what they used to be, where I could just see who I recently called, which might be someone who's involved in my criminal activity. It's pictures and letters and emails. And the Supreme Court said, no, the police cannot search your cell phone other than the most immediate information of who might be a co-conspirator. So there's clearly a trend in the law now to say, as the government collects more and more information, there's potentially a Fourth Amendment issue here. And we even have one district court judge in Washington, D.C., who said the 215 telephony metadata program was unconstitutional because he didn't say Smith v. Maryland was bad law. He said just that it doesn't really apply in a situation where we're engaged in massive collection. But in any event, we ultimately didn't conclude that we couldn't change the law in the constitutional analysis, and so just noted that there was a trend, but we didn't find, in our view, the program to be unconstitutional. There are cases now heading to the Supreme Court, and we may well get a definitive Supreme Court ruling on that sometime in the future. And then there's also a First Amendment concern, and that is by the government collecting your personal dialing records, the government knows who you associate with, and it knows what religious organizations you might belong to or attend, and the government also, people might feel less comfortable engaging in these kind of communications knowing the government's capturing that information. For instance, if you're a source for a newspaper reporter, particularly a source who might be in the federal government, not talking about leaking classified information, which we can talk about, but even unclassified information. If you just want to report there's a program going on that should be stopped, if you know that the government is capturing your calling records, you may be less willing to call a reporter. At least in our view, in my view, this kind of program chills freedom of association, freedom of religion, freedom of speech. But it's not the standard for striking down an intelligence program under the First Amendment, to say the least, is undeveloped. And so we noted those constitutional concerns, but again, ultimately couldn't conclude that the program was unconstitutional. So we looked at the statute, again, saw major problems. Constitution saw at least some concerns about it. And then finally, we turned to our policy analysis. And the policy analysis, again, starts off looking at the privacy and civil liberties aspects. As I just mentioned, I think that they are quite significant in terms of chilling speech and association, and really, in some ways, shifting the balance of power between citizens and government, that if the government follows your everyday activities, and yes, this program was about phone calls, but the government on the same theory could collect information about your credit card transactions, because terrorists use credit cards, your travel plans, because terrorists travel on planes, and so the government could start collecting huge amounts of information about everyday citizens without suspicion to monitor your behavior. And so we felt clearly that there were significant privacy and civil liberties concerns about the program. But that's only, we're not an advocacy organization. In some ways, life would be easier if we were, and just advocate for privacy and civil liberties. We also are required to balance those considerations with national security. And so you may recall, right after the Snowden leaks, the government released what they claimed were success stories about the operations of this program. And ultimately, it boiled down to about a dozen success stories that the program was effective. And so we, having the advantage of having security clearances, went to the government and said, we would like to see the files, the classified records of each of those dozen cases, and say what really happened in those, and was this program a contributing factor in whatever success might have occurred. After a careful analysis, and we share shared our factual conclusions with the government just to make sure we were getting the facts right, not our recommendations, just the facts. And it was all right. We ultimately concluded that there was not a single terrorist plot that had ever been thwarted by this program. But we also felt that that was not the only metric by which we should evaluate programs, because programs can serve other functions. So we looked at the so-called peace of mind, which is sometimes it's useful to find out there isn't a plot going on. We looked at the ability to capture co-conspirators. We looked at a number of other aspects because the programs can be valuable aside from the top-level concern of thwarting a plot. But even there, we found very limited success stories, and really only one sort of clear success story where someone was found and convicted of sending material support, which is money, to an overseas organization. But in terms of protecting the homeland, we found really no strong case, particularly where even there were some potentially helpful aspects to it, there were other legal authorities that could have been used to get the same information. So in looking at the whole picture, we concluded that when you balance privacy and civil liberties with national security, that the program was unjustified on a policy ground, and recommended that the program be discontinued. That's not to say that the government can't use this information and do some of these efforts, but what we said is that the government should go to the providers, the phone companies, on a case-by-case basis. That is, if a suspicious call, go to them and get the records just for that call, not for all of our records, and do your linking and your research to see if you can find something, but not to create a massive database of citizens' activities. And so we issued a 238-page report in January. We actually, as we were finalizing our report, we learned that President Obama was going to be giving a speech on reform of NSA the following week. And so we thought, rather than hold off sharing our report at the White House for 2 weeks when we'd actually be ready to publish it, we contacted the White House and said, we would like to share with you the draft of our report so that the President has the benefit of our thinking as he makes his decision. And the White House said, yes, we're happy to do that. And so we actually had our second meeting with President Obama in the Situation Room, where we had clearly read our draft report. I mean, he's quite an impressive person and was very thoughtful and had some very specific feedback for us, and basically indicated that he didn't necessarily share our views on the legality of the program, but as his speech showed the following week, he actually accepted our position that the program should be discontinued as a bulk collection program. And so we actually felt very pleased that the President had adopted our recommendation that the program shouldn't continue in its current form. Fast forward, as you may know, the USA Freedom Act was, and the President said that Congress should legislatively change the program. The USA Freedom Act was put forward. The House passed a version. The Senate passed a somewhat stronger version. And just 2 days ago, the program was filibustered in the Senate, and the bill was, and there won't be any reform this year, so we'll have to see what happens. The White House has indicated just today that they plan on making sure that that legislation is introduced next year, and we'll see. This program, the whole 215 program, which goes well beyond telephone records, includes lots of business records, expires in June of 2015. So something's going to have to happen between now and June, or the program goes away completely. And so usually in those types of situations, there's some sort of legislative effort. And so I think the White House would have liked to have seen that resolved now rather than been a brinksmanship in June, but it looks like we're headed towards a June, between now and June, some sort of resolution of this, or I guess it all goes away. And again, our board did not support it going away. We just supported the bulk collection efforts. So that was pretty much our effort on the 215 program. One other thing, a couple of things I wanted to mention is in the course of conducting our study of the 215 program, we held public workshops, as I mentioned, and at 2 of them we heard from judges who had sat on what's called the Foreign Intelligence Surveillance Court. And you may have read about that. That is the so-called secret court that approves government surveillance requests. And the court has been criticized, I think partly fairly and partly unfairly. I think the unfair part is that the government succeeds 90% plus times in when it makes its request to the court to issue surveillance orders. I think that it's unfair to conclude that the court is meaningless because there's actually a back and forth between the court and the court staff and the government. And so the government might make a request and say, we want to conduct a surveillance of some particular person, and the court staff might say you don't have the evidence or the legal support, and in some situations the government will withdraw its request or modify its request. And so the 90% reflects all the requests that have gone through that process, and so they don't really reflect some of the rigor that the court extends to these requests. That's on the, I think, unfair side. On the fair side of the criticisms is the court only hears from the government. These are closed hearings, they're classified information, and so the government goes before the judge. And as one of the judges told us, as a judge, when you hear arguments in a case, you hear the one side make their arguments and you say, that sounds pretty persuasive. But then if there are two sides, then you hear the other side and the judge says, well, that sounds pretty persuasive too. And it's the battle between those that really make our adversary system work. The problem is we're not getting an adversary process in the Foreign Intelligence Surveillance Court. And so what our board has recommended after a lot of study of this issue is the creation of special advocates. And these would be outside lawyers who, with security clearances, who would be brought in by the court when there were novel questions of law or technology, who could then go in and make arguments against the government's request. Much like the arguments that we found on the 215 program's legality, they could have made that, which perhaps it would have been better if they had made that when the program was being approved, and then the judge can consider those. In fact, in the 215 program, the court never even issued a written opinion approving the program until after our report came out, after years and years of operation. And so we think it would enhance the operations of that court to have someone coming in and challenging the government, not in every case and not automatically. If the government is doing something that's constitutional and legal, that's fine, which they often do. But if they're doing something new and different, then there should be someone in there opposing it. And again, President Obama accepted our recommendation, and the legislation that's pending in Congress would create a special advocate to do that, just that, and also try to make sure there's an appellate process. There have only been 2 appeals from this special secret court ever, and none of them have reached the Supreme Court. And one of the strengths of our judicial process is the appellate process, where the district judge gets reviewed, the Court of Appeals gets reviewed ultimately by the Supreme Court. And that's been missing so far in the development of surveillance law, and so we again thought that would be important enhancement as well. So the second program that we looked at was the called 702 program. And that's very different from the 215 program in a number of ways. One is the 702 program is focused on non-Americans, whereas the 215 program largely collects information about Americans. The 702 program is focused on non-Americans. And one of our jobs is to try to dispel myths about how these programs operate. And one of the myths was, the government only had to be sure 51% that the person was non-American before they could target them, suggesting that they were actually targeting a lot of Americans because they were being very lax about how they made that determination of non-Americanness. We took a very hard look at that and concluded that the government actually has a very rigorous program to try to determine someone's nationality, and is correct 99+% of the time in determining that the target is not an American. The second requirement under the 702 is that the person be overseas. So again, no collection can occur in the United States whether the person's American or not. And then the third requirement is that there be a foreign intelligence value to the collection activity. So there has to be some suspicion that they're part of al-Qaeda or engaged in some other improper activities. So only if this 3-part test is met, non-American, overseas, and foreign intelligence value, can you target somebody. But the targeting, again, is very different from 215 because the targeting here is of email communications and phone calls. And in this program, the government gets the contents of those communications. And not just the so-called metadata of who it's to and from, but actually what's said in these emails and phone calls. And so we, again, conducted an analysis of this program looking at statutory, constitutional, and policy, and by and large concluded that the program at its core was solid, and that is, under the statute authorized just what I described. The people at the time the statute was enacted pretty much knew what they were getting, and very few people were surprised when this program was leaked because the statute authorizes just this kind of behavior. So we felt that again, at its core, it's statutorily sound. On the constitutional side, one of the complications here is that even though you're targeting a non-American, non-Americans sometimes talk to Americans. They sometimes email Americans. Sometimes they make phone calls to Americans. So even though this program is not targeting Americans, there's still a substantial amount of Americans' communications that are captured. And so there is a Fourth Amendment issue there. The government conceded from the beginning that there was a Fourth Amendment issue, that this was a search of U.S. persons' information. This is one of the areas where we had some disagreement on the board. I actually dissented in part from our board's 702 report, along with Judge Wald, who is one of my colleagues, a former federal appellate judge. And our view is that the government should get a not a search warrant, but a court order when it searches its databases for Americans' communications. The board didn't concur with that, so that's a minority view. I think it's an issue that's going to come back. There's legislation that's even pending in Congress now that would ban all searches of U.S. persons' information. So I think it's an issue that we're going to be seeing again and again. But again, at its core, we felt that the program, even though they did not obtain a warrant under the Fourth Amendment, there's a foreign intelligence exception that may apply here. The searches still have to be reasonable, and we saw that there was court approval for the program and checks and balances throughout, and so we found that at its core it was reasonable. Again, some difference about how Americans' information was handled. And then the third part of our analysis is the policy analysis, which is to say, okay, does this program strike the right balance? On the privacy side, again, capturing the contents of your communications can be very sensitive. And again, the contents are not just, even if there's a foreign intelligence reason for conducting this surveillance, you still may get pictures of family, you may get intimate letters with loved ones, you may get lots of very highly sensitive information. So there's clearly a privacy interest and a potential civil liberties interest, again, because this could chill people's communication knowing this information is being collected. So again, we went to the next step, which we looked at how effective is this program with regard to national security. And in contrast to the 215 program, we found it was very effective, that a number of terrorist plots have been thwarted based on information that was derived from the 702 program. By the way, I should say that we announced our analysis of this program on July 2nd, 702. That was purely coincidental. It was not something we planned. But we found that the program was effective. It also was effective in providing important advice and information to the President of the United States and other decision makers in the government about activities throughout the world. And so ultimately, we did make a number of recommendations on how the program could be improved. For instance, on the foreign intelligence basis for conducting surveillance, we found that the government wasn't really documenting why there was a foreign intelligence basis for this collection. And sometimes it's helpful to show your homework because when you write it down, it helps people think through and articulate what their concerns are. And so we've recommended that the government start requiring its analysts to say why they think there's a foreign intelligence value in a little bit more detail than they had in the past, so that not only can they say it, but it turns out that when the targeting is done by, for instance, the NSA, the Justice Department and the Office of the Director of National Intelligence review all of those requests to make sure they're compliant. But if people weren't showing the foreign intelligence reason, it's hard to review that. By contrast, they were showing that the person was not American and why they thought that the person was overseas and why they thought that, just not as much information about the foreign intelligence rationale for this collection. So again, we did make a number of recommendations about reforming the program, but at its core, we felt that the program was sound. Maybe not surprisingly, we got a lot of acclaim from certain quarters on our first report, which we found the program was illegal. We got acclaim from different quarters on our second report, which found the program was basically legal. But in some ways, that's the, I think, important role that we play, is that I heard earlier that Plato is independent. We're independent also. And our independence comes, I think, as I mentioned earlier, I think, first of all, our independence is critical to our being trusted and doing effective oversight. And as I mentioned, we basically went to the president and said, we think this program is not legal. He said he thought the program was legal, and we're allowed to go ahead and vote and issue our report, even though we're part of the executive branch, without approval from the President or the Office of Management and Budget. In fact, the very day we issued our report in January on 215, the White House issued a statement saying, we disagree, we think the program is legal. We agree with the policy analysis, just not the legal analysis. So we are free to give testimony, to issue statements and reports without White House approval, which I think is critical to our functioning. In terms of going forward, where are we headed now that we've done these first two reports? Well, now we've gone from 2 staff people to 11, so we can actually do more than one thing at a time, and we've got about 10 projects underway. But probably the most substantial one is a study of a authority that the government has that probably a few people, I would ask you, you don't have to raise your hands, but how many people have heard of Executive Order 12333? Doesn't sound like very important, but it actually governs the entire intelligence community's operations. It was something that President Reagan issued, and it's been amended a couple of times by President George W. Bush. But in some ways, it's even more significant because it's the core operations of the intelligence community. And that you hadn't heard of it makes it all the more important for us to study it. And again, we have the unique advantage of with the security clearances, and many aspects of this program are highly classified, but with the security clearances being part of the executive branch, we can actually find out how this program operates. And so we're going to spend our time, we've already begun briefings from the intelligence agencies on how the program works. Don't expect a report from us anytime soon because it's a substantial undertaking, but we're a permanent government agency, and we're willing to dig in and do the hard work it takes to find out what's going on and to analyze the program. We're also in the short term, when President Obama spoke in January of this year, he announced Presidential Policy Directive 28, which doesn't sound very glamorous, but it's somewhat significant because it suggests that we should be treating non-Americans and Americans more comparably in our intelligence programs. And at the very end of that directive, he invited our board to conduct an analysis of the implementation of the directive and report to the president. And we've agreed that we will be doing that. And we expect the implementation process is scheduled to be finished in January. And so we'll then study the implementation and make our report. So those are the types of things that we are going to be doing. Obviously, there are 16 intelligence agencies, and we have a staff of 11, so you can do the math that it's, we can't be everywhere all the time, but we try to be selective in the kinds of programs that we analyze and report back to them. I should mention that, again, we're operating in a highly classified space. We were able, in our first 2 reports, to give entirely unclassified reports. The 215 program, we had the benefit of the leaks having occurred, and then a lot of information being declassified after the leaks. So almost everything was out there. That was not a challenge for us. But when we turned to 702, lots of aspects of that remained classified. But we felt that to tell our story, it was important to get some of those classified facts declassified. And we felt that some of them could be declassified without harming national security. So we had a dialogue, a very constructive dialogue with the intelligence community. And we were able to get 100 facts about the program declassified. And so we felt we could ultimately do an unclassified report to the public. Our first report, I think, was about 238 pages. Our last report was about 210 pages, not models of brevity. But we actually were able to describe in great detail in 60 pages how the program operates. And I don't think anyone has ever described an ongoing intelligence program with that level of detail. So one of the functions we serve is transparency, to explain to people how the program operates. We can have a policy debate about whether they should or shouldn't continue, but it's an important role that we play. As we turn to other programs, it could come the day that we can't do an unclassified report, but we always have the ability to do a classified report to the President and Congress to raise concerns about programs or show them our findings. But again, our first preference, whenever possible, is to do an unclassified report. And so that's what we're up to. And with that, I'm happy to answer questions.
Thank you for a very stimulating presentation.
Thank you.
Now we'll have our question and answer session. So hope you'll raise your hand, and if you have a comment, please make it brief, or if you have a question, make it to the point. And I'm going to ask the first question, actually. I'm wondering about privacy. The definition, I noticed you had a meeting, just public meeting last week to define privacy. I'm wondering, is it situational? What is it that makes it difficult to define privacy?
Well, we had a public meeting last week where we heard from academics and people from industry, government officials, technologists on what is privacy. And I started off the meeting by giving about a dozen definitions of privacy: the right to be left alone, the right to not have public facts, embarrassing facts about you released publicly, to control your information. Reproductive freedoms are considered privacy. There's no set definition of privacy, and that's one of the reasons that as a board charged with protecting privacy, we wanted to get input from the public about what constitutes privacy. There is no set definition. Again, some people think it involves control of information. We have, for instance, there are debates in our board and in the government as to, in the intelligence context, does privacy kick in when the government collects the information, or is privacy only relevant when the government uses the information? And lots of information sits in government databases that never gets examined, and so there's a debate whether that really raises privacy issues. My view is the privacy concerns start when the government collects it, as I said, because even the fact that citizens know the government's collecting it can chill civil liberties, but other people differ about that. So it's a subject where that's debated on and on, and there's no set answer.
Thank you.
Some of the 702 cases, people who were investigated were very upset about the gag orders that were associated with those investigations. Do you have an opinion about that?
Sure. I think you're referring to the fact that when a 702 order is served on a email provider or an internet provider, they're not allowed to disclose to anybody that they received the government order to provide this information. And obviously there are certain security and classification reasons why you would have that in place, but it was very frustrating to the companies to not be able to disclose, especially after the Snowden leaks, where the impression was they were, turning over huge amounts of information and raising concerns with their customers, and also their competitors had fodder against them. Our recommendation in our 215 report included saying that the companies should be given greater freedom to disclose government surveillance requests, and the government should itself disclose more about the nature of the surveillance requests that it make. After that, the government, Justice Department, and the key companies sat down and worked out a compromise that does allow the companies in aggregate to disclose certain information, and sometimes after a delay of 6 months or a year, because current information that can, again, compromise national security. But they've reached an accommodation that allows the companies to be more transparent, but consistent with national security. At least that seems to be working for right now. But we certainly recognized in our report that that was a legitimate concern.
There was an article in the newspaper last week about how Obamacare has ended up being very bad in terms of the HIPAA privacy rules. Can you give us some information?
Unfortunately, I can't. I did work on HIPAA, the so-called health privacy issue, in my prior life, but I've been spending the last year and a half focused on national security issues and not keeping up with it. So unfortunately, I wish I could, but I can't help you with that.
Okay.
There's some folks up front here also. Yeah.
I happened to have gone yesterday afternoon to see Citizen 4, which I'm sure you've been aware of. In the movie, they strongly implied that the metadata collected has other uses, and they specifically insinuated that what we have been accusing China of and Russia of and various countries, that is stealing technical information in order to unfairly compete, has been that we've been guilty of the same thing, using the metadata on what you're talking about. I'd love to hear you comment.
Sure. I have to say I'm unaware, from even after our examination, that the metadata is being used anything than for what it's supposed to be used for. I'm not even sure, quite honestly, how it could be used for competitive advantage for U.S. companies to collect millions of phone call records. So on a separate note, I mean, the government has asserted that it doesn't do any industrial espionage on behalf of U.S. companies as part of its surveillance program, and again, I have no reason to doubt that.
I've read that the internet providers now, in order to maintain their foreign business, are offering encryption to their customers. How does this impact the government's desire to get the information?
I think that's a really important question, and some of you may have heard the FBI Director Comey recently has raised some serious concerns about the government going dark and losing the ability to collect information. I think this is a really hard question. You have, again, two competing concerns. On the one hand, the government has found it very useful and has since the founding of the country, to engage in surveillance activities to protect national security. And if we're being deprived of access to those, it certainly risks our national security. On the other hand, there are obviously tremendous privacy concerns that have been raised by some of the surveillance programs, and these companies are responding to consumer concerns to protect their privacy, and they're doing it through encryption. It would be ideal if there was a way to have it both ways, which is if the government could go to a court, get access to it, the companies would provide it. But the way that companies have developed their encryption programs now, even the companies can't undo the encryption, only their customers can. So right now, I think we have two very important values in conflict. One potential suggestion is to create a backdoor in the encryption that only the government could use. But a lot of people have made the, I think, effective case that once you have that backdoor, you've created a vulnerability in the encryption, which ultimately harms a lot of things besides protecting those communications. So I think it's an important issue. I don't right now see a solution to that issue, but I think it's certainly accurate that the government has access to less information than it did before. Some would argue the government has access to so much more information in general, it still can do its job effectively. But I think it's an important issue that we're just beginning to wrestle with.
In terms of the long-term trends, there's one fundamental factor that seems to be emerging, and we're on our track to have about 9 billion people in the next 30, 40 years on the planet. And the recent projections show that estimated about a third of those people will be Muslim. So given that factor, what do you see as the long-term trend, and especially as we become more and more interconnected on the internet of everything? Is privacy and those kind of civil rights protections going to be really a fiction, and some of the just not going to be viable as we know it now?
I hope not. I mean, I think that protecting the rights of Muslims is very important. One of the things that we are looking at are suspicious activity reports that are filed locally, and we've met with the Muslim advocacy groups and the Sikh advocacy groups, and they're concerned that some of these reports are filed based on Muslims exercising their First Amendment religious rights to attend a mosque, and they shouldn't be targeted just because they are seen at a mosque, even with a group of other people. That's entirely protected religious freedom activity. And so that's one of the things that we want to look at, and to make sure that the criteria for making those reports don't include protected civil liberties activities. So I think it's a critical question. I think and hope that we can do things, take steps in the government through rules and regulations and oversight to make sure that that doesn't happen. Because that's, again, it's a community like other religious communities that should be entitled to constitutional protections.
I think am I speaking? I've heard from someone overseas that Skype is untraceable, Skype messages, because of the circuitous route that they take. So anyone speaking to someone in an overseas country from here, not internal, but it will never be traced. Is that true? I'm not going to comment on. I mean, okay, it's not a trick question.
One way or the other, because I think that those issues are best kept classified.
Okay, so that's my answer.
If I knew it all,
I've got my
so
answer.
sorry.
Thank you.
Yeah.
I grew up in the 60s, so I'm as paranoid about the government as the next person, but I worry much more that the next wave, when private industry, the people who are in the government now, they're in their 20s, and they want to make more money, they see the techniques available, they go into private industry, and we have a level of privacy for commercial reasons. It's much more subtle, but it's much more pervasive. Do you think things will develop in that manner?
I think actually a case could be made that the private sector today is gathering far more information about people than the government does. In fact, and some people argue that we should be more concerned about what the private sector is doing than the government is doing. I think there are some legitimate reasons to be concerned about the private sector activities, but in my view, we should be more concerned about the government because the government has tremendous powers over citizens of incarceration, of auditing tax returns, of doing lots of things to the citizens that the private sector can't. And so I think it's more important to have a check on the government. I was at the Federal Trade Commission, part of the debate about privacy in the commercial world, which I think is an important one and should continue. But I think focusing on the government's collection of information is an important function. And partly I also sort of grew up in the 60s, and I think that one thing to remember is that in the last couple of decades we haven't seen significant government abuse of information that the government collects. For instance, in the two programs that we examined, the 702 and 215, we never came across one incident of misuse of the information. I should also say that I have been tremendously impressed with the dedication and hard work of the intelligence community. I know they've been beaten up in the last year and a half. These are people who work day and night to protect the country without a lot of glory, and some of them go home at night worrying, did I miss something that's going to cause a terrorist attack? And that's a huge pressure that they carry every day. And so I've gained enormous respect for their work across the board. And again, we've seen no evidence. I'm not saying there's never been abuses, but we've seen none. And even what I've seen has been minor. But in the last century, we saw abuses that led to Watergate, the Church Committee, the FBI, even the Social Security Administration's records were used to round up Japanese Americans during World War II. So I think it's important to remember those lessons and think just because the government is benign today, which I think it is, that we should not create a situation where in the future, if we had a less benevolent government, they would have access to huge amounts of information. So once again, that's why I think it's critical to focus on what the government's collecting and that only collect what it needs and only keep it as long as it needs it.
I wanted to ask you, please,
Right.
your opinion as to whether Snowden was a whistleblower, is he a traitor, and what the impact that is on people who work in the government becoming whistleblowers or trying to disseminate information.
And you said that whether Snowden is a whistleblower or a traitor?
Yeah.
Expressing purely my views, I put him more in the criminal camp than the pure whistleblower camp. Obviously, I think he sits in both camps. But my personal view is that if Snowden had limited his disclosures to, for instance, the 215 and 702 programs that raise privacy and civil liberties issues, both for Americans and for non-Americans, I'm not saying what he would have done would legally justify, but I think it was a greater justification. But by being indiscriminate in what he leaked, including leaks that only harm national security and our ability to conduct surveillance of other countries the same way other countries conduct surveillance of us, I don't think there's any justification for that, again, in my opinion. So I think that one could question whether he was a traitor. I don't know, legally, a traitor is a legal conclusion, and it's that the Justice Department is addressing that. But I think whether he did was proper or not, I think that by releasing so much information without focusing on information that raised legitimate public policy concerns, it was not justified. In terms of whistleblowing, I do think whistleblowing is a legitimate activity. It turns out under federal law, if a whistleblower comes to our board, the Privacy and Civil Liberties Oversight Board, that person has legal protection. And so they can come to us and reveal concerns about a program, and they would get legal protection. And so I think it's an important function, and it's important that it be protected, but not having to go public about it, particularly where it compromises national security without policy benefits.
Thank you.
But I know others in this room disagree with that. Some are wearing buttons or were wearing buttons. And I think it's entitled, still are wearing buttons. I think it's a healthy subject of public debate, but that's just telling you my views about that.
I have two questions concerning your oversight and advice function of the board. As to oversight, to what extent, if any at all, has your board implemented protocols to determine whether or not the information it's getting is in fact truthful. I was thinking of Clapper's testimony before Congress where he said, well, yeah, I did lie. And do you have any protocols to at least attempt to verify the accuracy of what you're being told? As to the second portion, the advice function, to what extent is your advice actually being followed? In other words, is anyone listening to you, or is this something that just gets filed?
Sure. So the first question about the accuracy, I guess, and truthfulness of the information that we get. I would say that our approach to that is we have 5 members of our board, and anyone who's ever sat in a board meeting with us and been part of the government knows that we are very vigorous questioners. And so we ask a lot of questions of the government agencies we meet with. We also meet with multiple agencies and multiple personnel within those agencies, and so we can see if there are any inconsistencies in people's accounts of what goes on. We obviously meet with others outside. So I think we review underlying documents. So I can't say that the system is perfect, but I think we do have enough checks that if people were misrepresenting things to us, at least we would have a reasonable chance of determining it because we get our information from so many different sources. I'm not sure how much more we could do about that, but by looking at multiple sources and comparing them, I think we have a good sense of what's going on. In terms of advice, we are really just at the beginning of our advice-giving function. I think we're getting certainly acceptance about the advice we're given. If you can ask me a year from now, I guess, how much the government has taken our advice, but I think from all I'm seeing, they're taking it quite seriously.
So you've talked primarily about the data collection portions of these programs. I'm concerned about the maintenance of that data. It's my understanding that there are no limits on the maintenance of that data and that there are, huge data collection facilities being built in the Midwest to maintain all this data forever, and also about the subsequent use of this data, that, for example, in a criminal case, some police agency somewhere might be able to go back and trace the metadata for a particular phone number to collect in process of a criminal investigation or some other kind of investigation. And have you looked at any of that? Are there limits, any limits on any of that?
Yeah, I think there's a good question because, again, deciding what to collect is one thing, but how you use it, how long you keep it, who you give it to, are also very important considerations in a privacy analysis and a policy analysis. These programs have what are, I think, somewhat inappropriately called minimization procedures, but they're really controlled procedures about the information, and they do include data retention limits. And so typically after 5 years, if the information hasn't been used, it falls off and gets deleted. If it's used and analyzed and is relevant, then it can be kept, obviously, for a longer period of time. But one of the problems that we observed is that, again, so much of the information that's collected is never reviewed. And by the way, I should also say that the government is supposed to delete information that's not relevant to foreign intelligence when it's collected under these programs. So we had 2 problems with that. One is a lot of the information isn't reviewed, and so we had, I think, a debate, and there is a legitimate debate as to whether the government should read everything and then go through and delete the irrelevant parts. And obviously, if you require them to read everything, that raises more privacy concerns because there are lots of personal communications that would never have been read but for requiring them to read everything. And so I think in that balance, I think, at least I'm more comfortable with just letting the information age off if it's never reviewed. But there is, I think, another concern, which is of the information that was read, we saw very little evidence of deletion because nobody was willing to bite the bullet and say this is not relevant to foreign intelligence. We read it and we just keep it in the file. And this is another area where Judge Wald, who was one of my colleagues, and I dissented in our last report, and we said, we think that the Foreign Intelligence Surveillance Court, which approves these procedures, should go in and conduct a compliance effort to make sure the government really is deleting what it's supposed to be deleting. And we encourage the court to appoint a special master who would review information before the analyst saw it and after the analyst saw it, and see if the analyst was really deleting irrelevant information. And if they weren't, then the court should be more active in making sure that that process is taking place. So I think the answer is yes, we have looked at that. We've also looked at uses of the information. Again, most of the information is used for what it's supposed to be used for, which is foreign intelligence purposes. There's also Congress has authorized the use of the information for evidence of a crime. And so if information comes in that's not really related to foreign intelligence, but it says, I just kidnapped somebody or I'm about to rob a bank, that's information that the intelligence community properly turns over to the FBI to conduct a criminal investigation. So we're very sensitive to both retention and use. And as I say, I think more could be done on the deletion side of that equation.
By the way, I'm glad you're on the board. I think you do a good job.
Thank you.
I think you stated that the 702 program is quite effective. Is that program, I have a two-part question. Is that program in any jeopardy? That's question one. Question two, if the 702 comes up with some kind of an imminent threat, is there a way to accelerate reaction to that so that it's thwarted?
I'm not aware that 702 at its core is under jeopardy. I haven't seen legislation that would have seriously impair 702's operation. And again, I think the government recognizes and believes that the program is very effective and provides both in thwarting plots and providing valuable information to decision makers and for other areas as well. So I think it seems to be reasonably solid. Without getting into any detail, I think clearly the government is prepared to act promptly if it gets information that requires a prompt response.
I have a question, but it's complicated, so you can just say, okay, we'll think about that one. We're talking a lot about finding and uncovering stuff, but have we done any kind of psychological studies of what motivates other than just money or the people who participate in these activities? And would that be some way that we could, make the package a little smaller, not such a, I don't know if I'm being too complicated, but I think there's got to be certain motivations other than maybe just religion or this or money. But what's in the head of people who will go to great lengths to carry out these activities? I'm just curious. Thank you.
I think it's a good question about what motivates someone to become a terrorist. I mean, I think we have our hands full on those people who chose to be terrorists already. And I can't say because, it's a large intelligence community of people who are out there conducting that kind of analysis. That in some ways that's more of a concern for other policymakers about what steps we take in the world to address those potentially underlying motivations. I think there's certainly, we try through certain programs the government operates to communicate to the world some values, and I think there's a lot of misconceptions about what you're doing on behalf of religion and whether it's a minority part of the religion or a larger. So I think those are all legitimate questions, but as I say, our focus has been on those who've gone down that path. But I think certainly others might well think about how we prevent people from going down that path. I mean, we're seeing a lot right now people being attracted to go into ISIL in Syria, and what motivates individuals in the United States and other countries to do that is certainly a good question.
The terrorist groups are very decentralized. So what is the alternative way of creating this web of who calls who, and, if there's a suspected anti-U.S. person in Afghanistan, and they call somebody, you said, and then they call somebody else. If you don't have 215, how do you create that web?
Yeah, I think it's a good question, which is, again, 215, the ostensible value of 215 is to show what connections there are between terrorists outside the country and individuals operating in the country, whether they be terrorists or American co-conspirators or whatever it happens to be. I think the answer is that in our preferred approach, you can be doing the same thing with the telephone providers. That is, you don't lose the effectiveness of being able to do what's called contact chaining to show those connections. What you do give up is containing a massive database at the NSA of this information, and instead you keep the information with the phone providers. But I think the change before and after wouldn't matter. In fact, I was on a panel a couple months ago with General Hayden, Michael Hayden, who is the head of the NSA, and I was prepared for him to blast our recommendation about the program, and he actually said, no, he thinks it's more effective. There have been some reports recently that the government wasn't collecting wireless information as part of the 215 program, but if the government can go to wireless providers and get that information, it has more data available to conduct the contact chaining, the linking. So again, General Hayden thought it was more effective, and I certainly wouldn't dispute him on that. So I don't think we're giving up anything, but I think it's an example of how we can have both privacy and civil liberties and national security at the same time. And sometimes it's a matter of just doing things differently, but producing maybe the same or better results. And this is, I think, one example of that.
Within the last 30 days, a bank in Berlin, Germany, received an email purporting to come from me and requesting that a certain sum of money be transferred to an account in London. The bank obviously smelled a rat and didn't do it. About 10 days later, my brokerage in New York City got an email purporting to come from me, asking them to transfer an amount of money to this very same account in the UK. I picked up the phone, called the Los Angeles office of the Secret Service, told them this, because I believed Secret Service has something to do with it. The person I spoke with couldn't have been less interested. He just blew me off and he said, well, your bank will deal with it. Whereupon I sent an email letter to the appropriate department in the appropriate thing in the Department of Justice. I still have not even received an acknowledgement. Now, it seems to me that this kind of thing, especially going to an account in Britain where I don't happen to have a bank account, could conceivably be one way to finance terrorism or anything else. I am shocked at the lack of interest and the lack of follow-up on the part of two government agencies. Do you have any comment?
I mean, I guess I would go back. At the time I was with the Federal Trade Commission, identity theft was becoming more and more of a prominent issue. And a lot of people describe it as the fastest growing crime in the United States. I don't know if that still continues to be true. So I can't explain how the government agencies react to your request, but it may be in part that there's such a large number of incidences of identity theft that it's hard for them to get involved in individual cases as opposed to finding out a ring that's going on. But it's a challenging problem, and I could certainly see, as you point out, how it could have terrorism funding components to it. I mean, the government does investigate identity theft cases and prosecute them when it can. But it's also, I will tell you, the government does not have unlimited resources and is unable, even in merit-worthy cases, to always get involved in every single case. So I think it's a legitimate concern. I mean, the broader concern is we don't have a very good way of identifying ourselves to financial institutions. And if we had a better way, whether it's biometrics or multiple sources of validation, but I think in some ways it's telling that your financial institutions didn't respond to the email because they know that that's not a valid authorization, and they would either pick up the phone or use some other method to authenticate your request. And maybe that in part was why the government agencies weren't as concerned, is that everything happened properly in a sense, is that someone was trying to do a bad thing, and the financial institutions have procedures in place to prevent that from happening. But I'm certainly sympathetic that you would never want to be the person who's the victim of that type of activity, and you're afraid of when it might happen next. But that's why we have two-factor authentication and other methods to try to ensure that that's why when you call up your bank, they get multiple pieces of information about you and sometimes check the caller ID to make sure you are who you purport to be.
Edward Snowden's disclosures would indicate that government is collecting much broader amount of information than what you've talked about in these two programs. Do you believe there are other programs that you have not yet investigated, and will you be investigating them? It's my understanding in a very general way, he claims that all of our emails are being collected or could be collected at any given time.
There are undoubtedly other government programs that are going on. As I say, we've embarked on a study of Executive Order 12333, which is the umbrella authorization for countless activities in the various agencies, and we're beginning to learn more and more about how those agencies carry out programs. So there's absolutely more going on, and that's what that's our major focus. And so we will be looking at it, as I say, there's 16 agencies, intelligence agencies, and we have a limited staff, and so we have to try to be smart as we can about how we use our limited resources to look at programs that raise concerns, but that we're absolutely dedicated to that. Another problem, Qantas, we have institutionally is finding out what we don't know about. That is, these are programs that are highly classified. Even within the government, they're what's called compartmented, which is only a few people in the government even can know about them. And so that's going to be an ongoing challenge for us to even figure out how to find out what we don't know about. I mean, we do that sometimes because we ask questions in briefings, and they say, oh, it's compartmented. So we say, okay, let's read us into the compartment, and let's find out about it. And so we do find out about those, but that's going to be an ongoing challenge for us for a whole structure that's designed to be kept secret, and an agency that's going to conduct oversight. It's a challenge. I think we've been able to effectively get through to programs that we're concerned about, and we'll have to continue doing that in the future.
And specifically including, you talked about the concern about all the private sector, the data that's being collected in the private sector. Is there any reason to think that the government doesn't have access to all of that information?
Well, I mean, I think that's a legitimate question, which is there's private sector information that's available publicly to everybody. And so, the government can Google you just like I can Google you, or you can Google each other. So, obviously, I mean, that the growth in private sector information collection does have implications for the government's use of information because it's available to everybody. Absolutely.
Okay, we'll make this the last question.
Thank you for coming, by the way.
Pleasure.
I can see how your agency gets a lot of work done, just listening to you.
Very small staff.
Well, if they got guys like you, they can move a lot. Question, does the legislative branch, how do they do this type of oversight? Is there a comparable situation, or how do they handle civil liberties and privacy?
I mean, there are two committees in Congress, the House and Senate Intelligence Committees, that do conduct oversight. They're at least the primary ones conducting oversight. And then they have clearances, they have secure facilities in the Congress to do that. But they have a very broad focus because they're authorizing these programs on effectiveness and international relations and a variety of things. So it's something.
They have nothing comparable advisory.
Well, I mean, I'll leave that for others to judge, but we are a creation of Congress. Congress created us to advise Congress on these issues, these policy issues. I mean, our statutory mandate is to advise the President and Congress about our findings. And so we view our, even though we're in the executive branch, in some ways, we view a very important part of our mission is to advise Congress. We're required to report to Congress twice a year about our activities. When we do the reports that we've done, Congress and the White House are the first places that copies of the reports get delivered. And so we absolutely view ourselves as advising both ends of Pennsylvania Avenue. But that supplements what Congress has already done on its own.
Terrific. Well, thank you very much for a stimulating presentation.